Finally, I alluded to this before, the laws do also require employers to accommodate applicants, and in two ways, both in consideration of what job they'll be able to do if hired, but also in the application process itself, the hiring process, that is. So if someone needs an accommodation for their job interview, perhaps a sign language translator or some other sort of physical or procedural accommodation, then the employer has to engage in the interactive process and undue hardship analysis, just like an accommodation request within the workplace. It's important to note that employers have to make reasonable accommodations during the hiring process, even if it appears that the employer could not make the necessary accommodations if the employee were hired. So whereas it might be reasonable to have someone sign to facilitate the job interview, it would be more costly, obviously, as an ongoing matter, to have a sign language interpreter for the employee throughout the course of their employment. Nonetheless, you probably would have to provide that accommodation to the hiring process, even if you later said, we can't have you work here, because being able to speak over the telephone, for example, to other employees or customers, etc., is an essential function of the job. And you normally can't ask applicants whether they will need accommodation in performing the job unless the employer knows the applicant has a disability and reasonably believes an accommodation would be necessary to perform the job functions. You could know either because it's obvious from looking at the individual or because they have already disclosed it. But again, even if you know they have a disability, there would have to be some reasonable basis for wondering whether accommodation would be necessary. The mere fact that someone has a disability doesn't necessarily mean that they would need any accommodation or have any limitation in performing the essential functions of a specific job.